Our roots really go back to, I would say, 1963, and to some extent back to 1927. And I'll explain how we have these different roots and why one is 27 and one is 63. But let me start with 1962. In New Haven during the 50s and the 60s, urban redevelopment was a very big thing. And we had a mayor in New Haven, Richard C. Lee, who was mayor for many years and really was one of the national leaders in the whole field of urban redevelopment. He had a redevelopment team headed by Ed Logue, who was nationally famous and went to Boston after New Haven, went to New York after Boston. But as a team, they were able to get all kinds of federal assistance and money in an effort to redevelop New Haven. And an enormous amount of work was done, and neighborhoods were removed, people were relocated, a lot of new buildings were erected, the landscape in New Haven changed dramatically, but there was a concern at that time and for some time about what's happening to the people. While all this urban renewal is going on, where are the people going and what's happening to these low-income neighborhoods that were sort of vital prior to being destroyed? Where are those people going and what's happening on the human scale? And in 1962, the Ford Foundation got very much interested in this problem and decided it was going to spend money on what they called human renewal as opposed to urban renewal. This was the counterpart to deal with the other part of the problem, what was happening to the people. And so they funded programs in several parts of the country. There are a total of about 5 programs. New York had one, Boston had one, Washington, D.C. had one. There was one out in California. I'm not sure where the 5th was, but there were 5 of these programs. In New Haven, that program was called Community Progress, Inc. And the goal of the program was to create a catalytic organization that would have a dramatic effect on social service agencies in the community, in a sense of improving the quality of their work, enlarging the scope of their work, and making them more responsive to people and to the clientele that they were supposed to serve. The program itself was not essentially designed to be a service provider, but it was designed to change the mechanisms of many service providers and to enlarge and improve them. Although, in fact, it did both. It provided service and was very much involved in trying to improve social service agencies. At the time that that organization, Community Progress, Inc., was being created, there was a member of the faculty at the Yale Law School who was a Ford Foundation consultant, and his name was Joe Goldstein. He was a teacher of mine, a mentor of mine, a very good friend of mine, and they turned to him, the Ford Foundation did, and asked him for advice and input on this new entity, Community Progress, Inc. Joe Goldstein was not only a law professor, but he was a psychoanalyst, a practicing psychoanalyst. And having looked at the plan, he said, there are 2 thoughts that I have about things that I think ought to be included. One is we ought to provide a psychoanalytic opportunity, a training opportunity for grade school teachers to help them hopefully become more effective, more responsive to children that they're teaching. And the other plan that he had was we ought to have lawyers out in the neighborhoods with this Community Progress Inc., because Community Progress was going to have neighborhood offices, and he thought it would be good to have lawyers out there so that they could find out what's going on in terms of the legal needs of poor people and what they think ought to be done to try and address those needs. So Ford was impressed with these ideas and went to the person who had been designated to run Community Progress, Inc., and that was Michael Sverdlov, who was a good friend of the mayor, and the mayor and Ford and Sverdlov had been very much involved together in sort of designing and developing this program. And so Ford went to Sverdlov and said, we've consulted with one of our consultants, and we have a couple of proposals. And explained the proposals to Mike Sverdlov. And Mike did not like either of them and rejected them both. And Ford said, if you're going to go ahead with this program at all, you've got to accept one of these proposals. And Sverdlov's response was, as much as I dislike lawyers, and I do, I dislike psychoanalysts even more. So I'll take the lawyer program. And that's how it started, that we had neighborhood lawyers in New Haven as a result of the Sverdlov decision, all of which was initiated by Joe Goldstein, who remained very close to the program over the years, was really a guiding force and a mentor to many of us. So in January '63, this community progress program started. And I was one of the first lawyers in it. Gene Kahn was the second. The two of us started out January 2, 1963, each in a separate neighborhood office. I was out in Worcester Square in the Conti School. Gene was out in the Dixwell area in the Winchester School. We were brand new. I had just graduated from law school about a year or so before. I had not been to court. We didn't think it was necessary for us to have been in court. I remember Gene coming to me before we started and saying, Frank, what are we going to do? How are we going to do this? And I said, well, we'll just play it by ear, see what happens, and we'll handle it as things come up. There'll be people we can talk to, and we can consult. And I was young and perhaps foolish, but full of energy, and it was a very exciting kind of project. And so we joined on, and we started. Our role at the beginning was to sort of observe, see what kinds of problems were coming into the office, what kinds of concerns people had, and then discuss them and see what we could think of might be appropriate agencies that could be tapped into to provide service, or whether new agencies were needed. But we were really observers and in a way, referral people, or people who were seeking to solve problems in an innovative, creative way, because there were a lot of problems that had a legal dimension that didn't really seem to have a place for resolution. There was not much available. There was a legal aid bureau available at the time, which had a part-time attorney in charge of that bureau, and about 50 students working there from the Yale Law School on a semester-by-semester basis. But it didn't do litigation, and it really did not have the resources to provide the needs that people that we saw in the community needed. What happened very shortly after we started was that people, realizing that we were there, came to us with problems. And we, as I said, were both looking at problems in terms of what are larger solutions that may be available, where are referral agencies that might be available, or what, if anything, can we do? One of the problems that I got involved in at one point was a juvenile delinquency matter where the mother came to me saying that her son had not come home. She didn't know where he was, but he had been with some other kids, and they thought that he had been arrested. And what could I do? So we went down to the police station, and there was a juvenile division of the police department. They were holding this boy, and I think he was maybe 12 or 13, I don't know what his age was. But they were holding him for interrogation. And the mother asked me to intercede on her behalf and to speak to them and to get him out. So I said, I'm the boy's attorney. The mother has asked me to come here. I want to speak to the boy. Well, they weren't used to this. This was something new, and this was all before in re Gault had ever been heard or decided. Children didn't have any rights. Delinquency cases were treated as civil matters. The juvenile court and perhaps the police as well were acting in parens patriae, in place of the parents, not as prosecutors, but as parents looking after the best interests of the children. So who was I, the attorney, to be coming in and interfering with this parens patriae arrangement that the police had with the child? But not knowing any better, I proceeded ahead anyway, and I met with the child, and I said, look, you don't have to say anything. You don't have to say anything to police. My advice to you is not to say anything, and we'll see if we can get you released. But do not say anything. Well, I was able to talk to the child maybe for 3 or 4 minutes at the most, and they were at the door coming in. I had to leave. And I said, no, I want to talk to my client. I want to stay with my client because I want to see that he gets released and is able to go home. No, they said, coming in and coming toward me, you have to leave. And I said, well, not knowing what else to say, I said, well, if what you're saying is you're going to physically remove me if I don't leave, then I'll leave. So I left. And I said to him as I'm leaving, now remember, you don't have to say anything to the police. Don't say anything. They didn't take that as being particularly helpful for the rehabilitation of this child. They thought it was overly confrontational. The child ultimately got released to the mother and was treated as in the system as a delinquent. We did not represent the child further. That's the extent of my involvement in that. We had another case that came up in the other neighborhood that Gene Kahn was involved in, involving a rape in which a African-American young man was being charged with the rape of a white woman. He was being represented by the public defender, but the mother of the man was not comfortable with the public defender system. And she wanted Gene Kahn, who was our attorney in the Dixwell neighborhood, who was a black woman, to be there at the counsel table and to be with the public defender. And although she did not appear in the case, and we were not going to litigate really any cases at the moment because we were not in a position to do that, but she was there at the counsel table to give some support to the accused just by being there as at the request of the mother. Well, the newspapers picked this up and made a cause célèbre out of it. What was this social service agency that had just been created, funded by Ford, outsiders, with their outside money, doing, being involved in a case like this? It was inappropriate. And CPI didn't have any business being in this case. It was not part of the overall plan for the neighborhood lawyers to be doing this. So there was enormous criticism, but much of it was coming from the press. Dick Lee, who was very, very politically sensitive, did not like criticism at all. He came down hard on Mike Svierdorf about what the hell we were doing in the criminal court when there's a public defender in the case, and that was not to be an intended, or was not an intended part of our role. So Svierdorf, who was running the program at that point with his concerns, and especially this particular concern, about our being involved in individual cases and advocating for the rights of individuals when that meant going up against an agency that CPI was trying to negotiate with, work with on a much more cordial, genteel kind of fashion than confrontation and advocacy, that what we were doing seemed to be working at cross purposes with what he was talking about and what he was trying to do. So he didn't see how this legal services dimension to his program could work at all. And in 2 months' time, after we started in January 2, 1963, the program, the neighborhood lawyer program, came to a halt. It stopped. We were put on a very short leash, and we had to redesign or come up with a way to redesign the program. Jean left actually maybe 2 weeks after that, sometime in mid-March. She just left the program because she didn't want to be involved in the continuing hassle of this problem. What we did was we created a committee, a new committee, a legal advisory committee of lawyers in town who were sympathetic to the cause of providing legal services to poor people. That would be a guiding kind of committee for Mike Sverdlov so that he would have a sense of what the legal community thought was appropriate or inappropriate, because he just felt totally at sea and somewhat overwhelmed by lawyers on one side advocating one kind of a policy and no lawyers on his side. He hired himself a lawyer right away, and we had a group of people who were now part of this advisory committee. Well, that was the beginning. It really lasted two and a half months before it came to a halt. And it was part of the kind of the turmoil that legal aid in New Haven has had sort of from the beginning, from time to time. I mean, it varies in intensity and it's sort of cyclical, but it has been part of our history. Now, despite all of this, the Ford Foundation thought this was fascinating. This was a fascinating development from their point of view because it told them two things. One, there's a real need here for legal services for poor people. People want to use these services. There's a lot of need. It's just not being met. We've got to do something about that. And the other thing that it told them was you can't really run this kind of a program under the umbrella of a larger social service program. It just doesn't fit. It doesn't mesh. The methods of proceeding are totally different. Confrontation and advocacy are quite different from negotiation and compromise and the kind of thing that Community Progress was trying to do with other agencies. So whereas we were somewhat stressed out and at constant loggerheads with Community Progress Inc. and trying to develop a program that was going to be workable, the Ford Foundation thought this was a breakthrough. We have learned a lot and we can do something here. And what they ultimately agreed to do was to fund the spinning off of a new corporate entity, which was New Haven Legal Assistance Association. It spun off out of CPI and actually became incorporated in September 1964. So it took well over a year for it all to happen. But it stayed alive. The program continued on. I stayed with the program, although what I did was, because the mayor was feeling a lot of heat he felt as a result of what was happening, he was then inclined to give up the City Legal Aid Bureau, which was a city function and part of the ordinances of the city, to any new entity that was created if it would take it over and he would be involved in helping fund that arrangement, and Ford was interested in that as well. So I became the director of the Municipal Legal Aid Bureau at that point, and we had some new commissioners appointed, and that was sort of the counterpart to the creation of New Haven Legal Assistance, and ultimately in 1965 or 6, we merged, and we entered into a contract with the city to take over all of the function of the Municipal Legal Aid Bureau, and the city agreed to finance us in various ways. One was to provide housing for our program in the old City Hall Annex. They gave us lots of space, all free. They paid for our phone service, which they continue to do to the present day. And if you look in the ordinances of the city, you'll see that the ordinances relating to the Legal Aid Bureau are suspended pending the continued performance of this contract that the city has with New Haven Legal Assistance. Now, when I said earlier that our roots go back to 1927, having incorporated the Legal Aid Bureau into New Haven Legal Assistance, that bureau was started in 1927. And we are now that bureau as well as New Haven Legal Assistance, all now New Haven Legal Assistance. That was a bureau that provided civil legal services to people, poor people in New Haven, run by a part-time attorney, and as I said, with a large number of Yale law students, generally 50 or so per semester, who would go down there and work several hours a week, and did fantastic work, and had a manual that they created that was used on a regular basis to do all kinds of things. They handled eviction cases, paternity cases, bastardy cases as they were called then, bankruptcies, wage attachments, bank executions, and we got them by the dozens. We would have hundreds of cases, really, 200, 250 cases a month coming in there. All we did was give advice. We had forms that people could use. We helped people deal with problems that they had. But a part-time attorney wasn't enough to really be able to handle the problem. When I started then, I was full-time because Ford paid the other part of my salary to make me be able to take on that job. And we started for the first time litigating. And as I said, I was brand new. I really learned on the job. I consulted with people who are on our advisory council, Charlie Parker being one of them, Joe DeCessa being one of them, on a regular basis to figure out how to proceed and what to do. It's interesting, when we started representing people in eviction cases, that was something new. They had not been represented when they were being evicted. And what I did was I simply took the position that all of the defenses and all of the pleadings that were available in regular civil litigation should all apply to summary process, which is eviction litigation. And that's what we did. We simply incorporated and transposed everything over, and generally it worked. Although some judges would not allow discovery, for example, in eviction cases. That was prohibited because, as one judge said in an opinion, these are not civil actions. Now, what they were, if they're not civil actions, I don't know. But that was the language of the discovery rule. In all civil actions, you're entitled to this, and the way to get around that was to say, well, these are not civil actions. This is a special statutory proceeding, not a civil action, and you don't get it. That thinking has long been abandoned, and discovery is now readily available. But it used to be something that was talked about, that we were filing pleadings in eviction cases, and this was sort of unheard of. It was a novelty that this would happen. And when legal assistance first started up, a committee was appointed to examine all of our eviction files in the court to look at the pleadings to see whether they could find anything that we were doing that was inappropriate, unethical, illegal, whatever. And they had about 4 attorneys who were looking at these things, looking to see whatever they could find. And the report of the committee came back saying, we can find nothing wrong. One person came back and said, this stuff is pretty good. But the goal was to see if they could find anything wrong, and they could find nothing wrong. That was the report. When legal assistance started up then, having been incorporated in September of '64, a certain group, and a fairly substantial group in the private bar, were vehemently opposed to legal aid, to expanding legal aid. The argument was, we have a legal aid bureau, now we have a full-time person there, that's enough, that's all we need. Why do we need any more? This is a big expansion right there. There isn't the need. You haven't demonstrated the need for any additional legal services. We don't need it. There was also the concern that what we were doing was illegal or unethical. We were soliciting clients, we were advertising, we were going out and saying, we're here, we will represent you, and we will be able to assist you. There was a feeling that that was unethical. There was a concern by members of the private bar that we would be taking business away. We would be representing people who otherwise would go to a private attorney. And the example generally given was, if you were to take a divorce case for somebody who was being divorced and they needed to be represented, that case would probably have been handled by the private bar, because that person, one way or another, would come up with the money. They would get it somehow. And the example was, if a woman is being divorced, she has a boyfriend, and he'll pay the money to represent her in the divorce and that kind of thing. So there was this big fear that we would be taking cases away from the private bar, fee-generating cases or fee-paying clients, and that they would lose business. There was a fear that we might change the standard of practice. Look at summary process. Nobody was, landlord attorneys would go in and get judgments. Nobody would appear, nobody would plead. So now there was going to be a new kind of practice going on if we were going to be involved in cases where nobody had been involved before. So there were meetings of the local county bar association, the most highly attended meetings that they had ever had. They stopped serving roast beef because it was too expensive. Because too many people were showing up for these wonderful roast beef sandwiches that they would have. But it used to be 15 people maybe would show at a meeting. Now we were having 50, 60, 70 people showing up at these meetings. So they couldn't feed them. But the people were there, and the attacks on New Haven legal assistance were really vehement. We were outlanders. We did not belong. And we didn't understand, the practice. And so at one of the meetings, our new executive director attended because they had a lot of questions, and we thought it would be sensible if he be there. We assumed that they would call him in and want to ask him questions, but they didn't want to let him in. He was not a member of the bar of the state of Connecticut yet. He was from Washington, D.C. And he certainly was not a member of the county bar and a member of the association, and therefore, even though he was right outside the door in the courtroom, and it's the housing courtroom that this was taking place in, the third floor courtroom, they would not invite him in. So they had to take a vote, and there was a big debate about whether to invite him in or not, and ultimately by about 2 or 3 votes, it was decided he should be invited in to explain the program. Makes sense. Have the guy come in, at least let him know what the program is about, if they're ever going to discuss it and try and vote on it. So I went out to bring him in, and I said, Fred, these people are crazy. This is really, really violent here. So, be careful. And I thought, how's he going to do this? Now, he had been a professor of evidence down at American University. He got in there, and they started asking questions, and he fielded those questions in a marvelous way, like a professor in a classroom with students. A question was, well, do you have, what can you tell us about the need? Have you documented the need for free legal services for poor people? He said, well, that's a good question. And that's one of the questions we're going to look at. We want to look at that carefully to see exactly what the extent of the need is that we have here. And so every question that was focused at him as an attack, it rolled off. He was able to pick it up and expand and enlarge upon it and make it into really a kind of an academic inquiry. That we were going to look at this, and we were going to proceed in a deliberative kind of way. We were going to ask for advice of counsel with respect to claims that are being made that were violating the canons of ethics. We were going to get an opinion. He really diffused that kind of hostility, at least for the moment, at that meeting. They could not reach him. They could not find buttons to press. He was really cool. And I thought when this went on, I thought, we got the right guy for this job because he was able to handle that so nicely. Ultimately, though, at the end of that meeting, the majority voted against New Haven Legal Assistance. They did not want a legal aid program in New Haven. They saw it as being too involved with social work that we were, and not something that was solely a legal program. We were going to do some studying of the need and studying of delivery systems. In fact, we had several different kinds of plans for different kind of delivery of legal services in the community. One was a Judicare kind of plan, that we would have an office where we would refer out pro bono and we would have money to pay. And one was the staff attorney program, that we would have regular staff attorneys who would do the work as opposed to referring cases out. So there were a range of different ideas that we were exploring in connection with delivery of legal services. Ultimately, it was decided that the state bar ought to pass on this, and I think it was the ethics committee that was asked to review what we were doing and to rule on whether we were doing things properly and abiding by the canons of ethics and so forth. They sent us a series of questions, like interrogatories. We had a set of interrogatories that we had to answer. And we prepared answers to those. The committee reviewed that all and ultimately concluded that there was nothing that we were doing that was improper, illegal, or in violation of any of the canons of ethics. And at that point, we proceeded. We held off opening up an office until we got that ruling from the state bar. And then we opened up offices, and we had neighborhood offices on on Congress and on Dixwell. Those were the first two offices. I think it was New Hallville, actually. Those were the first two offices that we opened. We ultimately had maybe 7 or 8 offices going at one point, but that's how we started. In '65, started getting money from the federal government. The Economic Opportunity Act had been passed in 1964. Money was being made available for legal services programs in '65. And we were one of the first programs in the country that got funded through federal funding. This was a very dramatic change from the past. The federal government had never been involved in funding legal services. At this point now, we had Ford Foundation funding. We had some local funding, and one of the things that we did was seek out ways to find funding. We had, at some points, at the very beginning, 10 or 12 different sources of funding. And now the federal government came in and became a major supporter of our program. We're one of the few programs that got funded for our criminal defense work as well as civil, and that's because we always, when we started New Haven Legal Assistance, we always had a criminal defense component, and the Federal Legal Services Program agreed that we would be grandfathered in to continue that. So we've always had a full range of both civil and criminal defense. I'm at a point where I'm beyond the time that I wanted to limit myself to, because I have to go over to a meeting that I have going on right now. So there's far more to this. There's far more to this, but those are the beginning years. That's how it started, it has been on a regular basis a program that, because of what we do, because it's confrontational, adversarial, because of our advocacy, because we are involved in trying to bring about change, that we have, from time to time, difficulties with funding sources, political difficulties with different groups, certainly with the Congress over the years, and certainly with the Legal Services Corporation. And I'm sure Pat will tell you about what our relationship now is with the Legal Services Corporation and with our funding situation vis-a-vis them. But that was the beginning. So.